Today's topic of discussion will be state liability. Before we discuss state liability and the main cases and principles around this topic, I would like to refresh your mind on general rules that is very important for you to know when you answer your assignments. Many students think that they are aware of IRAC structure, issue rule, application conclusion structure for problem questions. However, I see a lot of mistakes in the tutoring sessions that students make applying IRAC structure. The main mistakes that I see from students' answer is that firstly, they copy and paste the facts of the case. When you state the issue, by identifying the legal issues, you need to say what is the legal issue in the problem question at hand, rather than copy and paste the facts of the case. Secondly, the application of the relevant laws is a very important step. Many students do not identify the most relevant laws that should be applied to the facts of the case. The key here to remember is that there are a lot of cases and principles may be applicable. However, you need to focus on what your professor has emphasized on the lectures. So you have to have a look at your lecture slides and make sure that you apply the most relevant cases and principles that your professor has been focusing on the lectures and the seminars. Also, if any kind of further guidance has been given by the professor for the assignment or for the exam, make sure that you follow them, because the grading is subjective and every professor have their own criteria of what should be mentioned in the answer. So make sure that you are very well aware of what you are expected to do for your particular course, for your particular professor, and make sure that you follow the university's guidelines in as much detail as possible. Application analysis part is the most difficult, and most of the time students lose marks in this step. In the application analysis part, you're required to apply the facts of the law that you have identified to the facts of the case. And you need to make arguments. This is where you demonstrate your legal skills. And this is where you need to show to the examiner that you not only know the applicable law, but you are able to apply the applicable law to the facts of the case and make arguments. These are very high-level legal skills for which you will be marked. You will be given a high score. However, if you're not able to identify the right law, and if you're not able to apply to the facts of the case correctly, make convincing analysis and arguments, you will not be able to get a high grade. Essay question style is a bit different from problem question style, and it is very important that you know what you're required to do in an essay question. Although in EU law, mostly you get problem questions, you may also get an essay question, and you should make sure that you are very well aware of what you need to write in an essay question. Straightforward way of going for answering an essay question is to argue for and against the statement that has been given to you, for and against the question that has been given to you. However, most of the students, what they do when they see an essay question is they see what is the topic of the essay question. For example, if the essay is about state liability, what they do is to just write everything they know about state liability, and that's a wrong way to go. You should not write everything you know about state liability. You should answer the question asked. And by answering the question asked, most of the times they say provide critical analysis for a specific statement, and make sure that you argue for and against the statement. So when you present the arguments for and against the issue of discussion, that is critical analysis. That means that you understand the legal issue at hand, and you are able to provide critical analysis by showing the advantages and disadvantages and showing different angles of the topic that you can approach. Now we can discuss state liability. When member states breach their obligation under EU law, individuals can apply for this remedy. Individuals can apply for breach of directives. That's another topic But now we're going to talk about state liability specifically. State liability often comes as a mixed topic in a problem question on exams, and it's usually mixed with direct effects of directives. So make sure that you practice on answering the problem question on this topic. Good news is that we have a model question and answer on this topic of first class. It was awarded high first class. So make sure that you have a look at that question, you draft your own answer, and then you compare your answer to our answer, so that way you understand what you did right and what you did wrong and where you need to work on. Under the principle of state liability, member states are liable to pay financial compensation for breaching EU law. This was established under Francovich case. It is very important, if you are going to answer the problem question of this, that you know the key case, which is Francovich. Francovich is the key case for state liability. You need to mention it in your answer. Here, the court established criteria for claiming damages from a member state in the context of a breach. So if a member state breaches EU law, Francovich criteria has to be applied in order to claim state liability. And here are the three criteria. The directive involves rights conferred on individuals. So the person who is claiming, the claimant's rights have to be involved. The content of those rights could be identified on the basis of the provisions of the directive. And thirdly, there was a causal link between the state's failure and the damage suffered by the persons affected. So it can be brought by one person, it can be brought by a group of claimants. There has to be a causal link between the state's failure to implement the EU law and the damage that has been suffered by the claimants. Also, a very important case, Brasserie, where a member state acts in a field in which it has wide discretion, as legislatures typically do, and individuals' right to damages will depend on three conditions. The rule of law infringed must be intended to confer rights on individuals. The breach must be sufficiently serious. There must be a direct causal link between the state's breach of its EU obligation and the injured party's laws. So in other words, this case is kind of narrowing down the scope of application of state liability doctrine so that we don't have floodgates of liability, because not every EU citizen can be claiming damages from their member states for every failure of implementing the EU laws. So that's why this case is narrowing down the criteria, and it's very important that the breach is sufficiently serious. If it's a minor breach, the damages cannot be claimed. If a state fails to implement an EU directive, the state must compensate the individuals. The damages has to be offered. In an essay question, you can mention that these damages indicate that the Union law provides remedies and protection for individuals who have suffered as a result of the member state's failure to implement an EU directive. It is very difficult to define what is sufficiently serious, and most applications to the CJEU fail on this requirement. However, as far as we're concerned, you're not required to say in the problem question whether or not what is happening in practice. So even if sufficiently serious requirement is quite hard to prove, you're not required to prove it like if you were a lawyer. You just need to say in the answer or in your answer what is the test applied to the facts of the case, and say how likely it is that your claimant, the party that you're advising in your answer, can succeed if he or she claims state liability. This test is most difficult to prove, but there are some guidance from different cases that you can use and you should mention in your answer. The decisive test for whether a breach is sufficiently serious is whether the institution concerned has manifestly and gravely exceeded the limits of its discretion. So basically, it has to be really something very, very serious breach, rather than just a minor breach of the directive or EU law. The clarity and precision of the rule breached, the measure of discretion left by the rule to the national or union authorities, whether the infringement and the damage caused was intentional or voluntary, whether any error of law was excusable or inexcusable, and the adoption or retention of national measures or practices contrary to union law. So you need to argue in your answer that the breach that on the facts of the case that you've been given is inexcusable, is very serious, has very seriously affected the party that you're advising. It's inexcusable. And more you can provide arguments for how serious the breach is, higher chances you will have to prove to the examiner that the breach is sufficiently serious, you understand the law, and you are able to provide convincing arguments. Important cases to read are the following. Principles of state liability, principle of procedural autonomy. It's important that you read the case of Roux. Sufficiently serious. Queen versus Treasury ex parte British Telecommunications is an important case that you read, and you will receive the slides after the session, and you will be able to have a look at all these cases on our website. Now, I would like to take you through a problem question on directives and state liability, an example problem question that you may be getting on your exam. EU enacted the Directive 2015 in March 2015. The directive was to regulate new startup businesses. According to the directive, when the startup is making profits, they would be required to put 7% of it into a protected fund to have compensation secured for employees if the business goes bankrupt. Since startup employees are often at risk of losing their jobs, the directive was created for the purposes to protect them. Spain has not implemented this directive despite the deadline by March 2017. Martin, a Spanish national, joined the startup and lost his job. Soon after the company was launched, Martin wants to get compensation. This problem question raises different issues, such as application of direct and indirect effects of directives, but we're not going to discuss that. We're just going to discuss the state liability part. We have a full answer to this problem question on our website, and I highly recommend you to practice with it. Make sure that you answer the question yourself first, and then you compare your answer to our answer so that you know exactly where you went wrong and where you need to work on. This is a model answer, and it's a first-class level answer. The problem question requires discussion of direct and indirect effect of directives, and the answer can be accessed through this link. State liability is a remedy available to EU citizens when member states breach obligations under EU law. So very briefly, we have defined what is state liability in our answer, and we have cited the right case. Member states must provide financial compensation to individuals affected by the breach. State can be liable for non-enforcement of EU law, in this case, non-implementation of directive. As you can see, we are very on point. We are only discussing the laws that are relevant and applicable to the facts given. Many students just discuss everything they know about state liabilities, and that's where you lose marks, because the problem question is not asking you everything you know about state liability, every case you know, but the relevant ones. The relevant to the arguments that we are going to make when we advise the party here concerned, which is the person who is trying to bring a claim against Spain for breaching the directive. The state liability was further clarified in Brasserie. The following test was established: a specific right must be conferred upon an individual. The breach must be sufficiently serious. The causal link between the breach by the state and the damages to the individual must exist. we need to apply and conclude. Applying the test, the requirement for startups to pay 7% of their income to a security fund would grant a right amounting for compensation in case of bankruptcy. So now we are applying the facts of the case to each and every step of the test that we set before. And we make sure that we make arguments. So the first requirement is satisfied. Secondly, due to non-implementation of the directive, Martin was left without a compensation and without a job. Thus, breach could be argued to be sufficiently serious. So we show to the examiner why the breach is sufficiently serious. The person was left without a job. This is a serious consequence. Thirdly, a causal link can be established. Due to the state not implementing the directive, the startup did not have a security fund and Martin did not get a compensation. So there is a direct link to what has happened to Martin and state's failure to implement the directive. To conclude, Martin would have a chance of a successful claim under the state liability doctrine. As you can see, we did it very clearly and only applied the relevant law step by step and concluded that Martin would most likely have a successful claim under state liability doctrine. And this is the way to get a first class. Important cases to read on for state liability: Francovich, Brasserie, and Directives. Make sure that you click on these links when you receive the slides and read these cases. Also, it's highly recommended that you read our model answer in full on this for this question, so that you understand what you're required to do if you aim for a first class. Now I would like to discuss very briefly what our company offers and how we can help you. We are a group of top students and graduates who have all achieved very high grades in our respective law degrees, and we have created simple studying to help the rest of the law students have the same success as we had. We offer simple study resources focusing on getting high grades from our own experience. All our materials focus on students getting high grades as quickly and easily as possible. We have simple notes, model essays, tutorial videos, quizzes, and flashcards to help you get high grades as quickly as possible. If our resources are not enough, we have an additional service that we offer: one-to-one tutoring sessions. This is very helpful for students, especially in the exam season when they are very stressed and they can be confused and they need some one-to-one personalized support for their legal studies. We can help you in various things, such as planning your assignment, or help you to prepare effectively for your exam, or anything you may be struggling with in your legal studies. You can book a tutoring session via the link indicated on this slide. We have already helped thousands of law students to get high grades, and 90% of our regular premium users get a first class. We would love you to be our next student to get high grades. Please join Simple Studying now and join our study groups on WhatsApp from this link. Thank you very much.